Hello everyone. I welcome you all to a panel discussion hosted by the Center for Computational and Economics titled Digital Competition Bill 2024 in India. Is there a denial by delay? I am Sumit. I am currently working as the director at the CCLE. We have a great list of panelists with us. We have Mr. Peri Bishay, who is the case handler officer in digital platforms at the DG Comp European Commission. Then we have Dr. Shilpi Bhattacharya, who is professor at Jindal Global Law School. Then we have Mr. Keldon Baster, who is the executive director at the Canadian Anti-Monopoly Project. Just a brief background before we start with this discussion. The Indian government last year, 2024, somewhere around mid 2024, proposed to have a law known as Digital Competition Bill on the lines of the Digital Markets Act, which is right now there in European Union. The law proposes ex ante rules for certain gatekeepers, which in India would be known as SSDs, which is significantly systematic digital enterprises. The law, there is some academic commentary available in terms of what are the similarities between the DCB in India vis-a-vis DMA in the EU, and what are the differences between these two laws. As the timeline clearly mentions, even though this law was proposed a year back, not much has sort of transpired on the legislative end. However, there has been some executive developments. The nodal competition body in India, which is the Competition Commission of India, has recently passed a contravention order against Meta, which was earlier known as Facebook, in the WhatsApp case. The crux of this matter revolved around cross utilization of data, which is being obtained through WhatsApp, and this specific group using this data to leverage in other segments, specifically in its advertising domain, to profile the users. There has been some development on the executive side in a case pending against Amazon as well as a case against Apple. However, no final word is available, and all this information currently is pending before the CCI. With this in background, Perry, thank you so much for accepting our invitation and speaking on such an important area of law. Perry, I would like you to start, with the Digital Markets Act. Right now, a lot has been already written on it. A lot has been already been commented on it. There are two contravention orders which the EC has already passed. One against Apple and the other one against Meta. Right. The European Commission is also right now having workshops, right, which is quote unquote known as regulatory dialogue, right, to ensure that there is robust enforcement of the law. If you can, I pass on to you, if you can, spend some time in terms of, what are the successes and what are the limitations which European Commission is observing when it comes to competition in digital markets, not only through the DMA but also through Article 102, which is the conventional competition law in the EU, right? And what are the possible lessons? Perry, over to you.
Thank you, Sumit, and thank you for the introduction, and thank you for the invitation to speak today. It is my pleasure to be here. I'll spend a few minutes because it's a very broad question and topic, and I think there's plenty of things to say. I think it is fair to say that with the DMA we have started a new era of regulation of online platforms in Europe. As you said, the DMA is an ex-ante regulation, and it specifically targets conducts that we know are either anti-competitive or detrimental to business users, consumers, and the economy abroad. So this is, the DMA allows us to address all these issues proactively. The DMA is what we call an asymmetric regulation, meaning that it only applies to designated gatekeepers and only to certain of their services, right? So the DMA doesn't apply to the whole of Apple or to the whole of Microsoft or to the whole of Meta. And once a gatekeeper has been designated, it needs to comply with a number of well-defined and balanced obligations, right? So there's a list of do's and don'ts. The DMA obligations became binding on the gatekeepers over a year ago, so on the 7th of March 2024. And over the past, 14 months, we have really focused on monitoring the compliance of the gatekeepers with the DMA, right? The way we have established our enforcement strategy is based on two pillars. The main one and the most important one is what we call the regulatory dialogue. This means really discussing openly with gatekeepers about how they need to comply with the DMA, being transparent about it, and discussing in parallel with the different stakeholders, be it beneficiaries of the DMA, consumer associations, basically everyone that is involved. You mentioned the workshops in your introduction. The workshops that we organize are part of this regulatory dialogue. So we had a first set of workshops where we invited the gatekeepers to come and present their compliance solutions. And then the relevant stakeholders could ask questions in order to better understand, in order to raise some concerns, or on the other hand, to confirm that the way that the gatekeepers had complied with the DMA was satisfactory. And we had the second round of compliance workshops just last week. So this is really part of our regulatory dialogue strategy. And of course, when we see that the regulatory dialogue is not working, then we will open formal investigations. Just a few months ago, in April, we issued our first two non-compliance decision under DMA, and you mentioned them. The first one is Apple, where we found that Apple didn't comply with the steering obligation that's enshrined in the DMA. For those that don't know, steering really means informing users about better offers within the app. So for example, you have an app that is based on a freemium model. So you download it for free, you start using it for free, then you want to take a subscription because you want a better service or for whatever reasons. Usually you have to do this via the app and you don't really have a choice. And we all know that Apple and Google charge a commission fee that's relatively high, and then these developers need to pay. With the steering obligation, we allow developers to tell, hey, I saw you want to subscribe, you can subscribe either here, or if you want, you can subscribe on my website for cheap, and here's a link, please click on it and take your subscription there. The second non-compliance decision that we issued was against Meta for this pay or consent model that they basically rolled out in Europe, saying if you don't want your data to be used mainly for advertisement purposes, you pay. And if you don't pay, then we will use your data for advertisement purposes. And we think this binary choice is not compliant with the DMA. We have 3 non-compliance proceedings ongoing, so we're not quite done yet. I mentioned the case against Apple and steering. We have also the same case, but against Google. We also have another case against Google for self-preferencing on its search core platform service, where we have concerns that Google is favoring its own services compared to those of competitors. And the third non-compliance decision proceedings that we have is against Apple for what we call the business terms for app distribution. So under the DMA, it should be able to have alternative app stores on Apple's devices, the iPhones and the iPads specifically, and we have some concerns with the way that Apple has rolled its solution. In addition to non-compliance proceedings, we have this tool of specifications. So certain obligations in the DMA can be what we call further specified. So here is basically we give additional guidance to gatekeepers on how they need to comply. And we issued our first 2 specification proceedings against Apple. The first one concerns measures to facilitate and increase interoperability with iPhone devices. So for example, if you have AirPods, they'll naturally sync much easier with an iPhone. If you have another brand of headphones, they might not pair so easily. So the idea with all these specification measures is to make sure that these non-Apple brands have access to the same functionalities as the Apple software and products and basically compete and pair. And the second set of specification measures was really to streamline the access to interoperability requests. So if I'm a developer, I want to interoperate with Apple, I lodge a request, and I just want to make sure that my request will be handled swiftly, and if it gets rejected, it gets motivated, and then I have some sort of mechanism to appeal or contest. So this is where we stand really. And as I said, the main pillar of our strategy is really this regulatory dialogue, and we have also achieved a lot of things via this regulatory dialogue, right? For example, now Apple introduced choice screens. So when you have an iPhone, you get a choice screen asking you which search engine you want. For example, this was not the case before the DMA, and this, we discussed at depth with Apple on how this should look like, how it should be presented, when it should be presented. If users change their mind, where do they need to go in the settings to change their choice? I also mentioned the availability of alternative app stores, although, as I mentioned, we're not fully satisfied. And we have also given end users greater control over the data. And this is particularly important in social medias, where if you want to change from one social media to the other, you should be able to port your data, right? So this is a bit where we stand, and it's quite a lot of work that we have done, and I think we also have a bit of basis to understand, what has worked, what is working a bit less well, and basically lessons that may be of interest for jurisdictions such as India. And we have Keldon on the call, and I know that Canada is also looking at this, or at least rules for digital, right? And as I've already emphasized this, but I think that the main strength really is this regulatory dialogue with non-proceedings up on our sleeves, right? Gatekeepers will be more willing to engage openly and discuss and put solutions on the table than everyone can comment and therefore be transparent about it when they know that if it doesn't go well, they might face formal non-compliance proceedings. So this has really turned out to be a really powerful tool. Something we have in Europe that's maybe more specific because we're, a constellation of 27 member states in the European Union is the private enforcement. So we've already seen some actions in some member states where companies go directly to the judge saying, we believe the gatekeepers have not complied with the DMA. So in addition to the public enforcement, you also have the private enforcement, which is a further incentive for gatekeepers to comply. Something that we have really put a lot of effort into is to have also a mix of people. And this is really relevant for the authorities that are looking into this. We have a mixed team of lawyer, economists, technologists, computer scientists, just to make sure that we have obviously the legal capacity, because we're still talking about a legal text, but more importantly, the technical capacity to really understand what we're talking about, right? When we're sitting at the table with gatekeepers, they will bring their IT teams, their engineers at the table, and we need someone that can talk to them, right? That can talk to them and that can understand them. So it's really important, and this is something we've done relatively successfully, is really to have this mix of people to make sure that the DMA is enforced properly. Another lesson learned is the timelines. there's this criticism, I guess in Europe, maybe less in India or Canada or other jurisdictions, is that antitrust proceedings take too long. We are talking about digital markets that change very quickly, that tip very quickly. So if you don't act fast enough, then it's too late. And basically issuing an antitrust decision 4 or 5 years down the line doesn't really change anything. So this is why we had these ambitious timelines for formal investigation in the DMA, which is, a sub deadline of 12 months for non-compliance and a hard deadline of 6 months for the specifications. And so this has really helped ensuring a rapid enforcement of the DMA. And we've managed to also put on the side all the complexities of antitrust, right? If you're a gatekeeper, you're a gatekeeper. We don't need to demonstrate a dominant position. We don't need to demonstrate an abuse of dominant position. I talked quickly about the specification decisions against Apple, and this has also proven to be an efficient tool, right? It has given us the possibility to give clear guidance and clear instructions to gatekeepers on what they need to do to comply in a very short period of time. In specification proceedings, we need to go out to the market saying, this is what the gatekeepers have proposed. What do you think? So there's an element of transparency. And it's an approach that's very collaborative, right? So what we adopt in specification decisions has been market tested, and we know it's something very tangible. So this is a tool that has been very efficient because maybe non-compliance, we don't have this collaborative aspect, right? It's more litigious, so maybe gatekeepers are less willing to help. And finally, the last 2 points that I quickly wanted to mention were that the first one is that we have tools in the DMA to make sure it evolves with its own time and with the new challenges that we see rising, right? So we have future-proof and flexible mechanism in the DMA, right? So we'll be able to revise the DMA every so often. We can do market investigations to determine if we need to designate gatekeepers, even if they don't meet the thresholds. And we have, a wide circumvention prohibition. So if we see that there's some sort of malicious compliance, we still have the tools to act. And the last one, and I think this is also very important for the regulator, is that the DMA establishes a cooperation mechanism with other authorities. When we're speaking about personal data, obviously we're quickly into the territory of GDPR. What is the definition of data? What is the definition of personal data? And there's a strong, interaction with other instruments. So we need to be coherent. So we have a mechanism where we will coordinate and discuss with other authorities. So we have the telecoms authority, we have the data authorities, we have the consumer protection authorities, and this is to ensure that the DMA is really enforced consistently with other tools. So I think all in all, this is roughly where we stand in both of enforcement and of lessons learned. But always keeping in mind that it's a very new tool, right? And we've only been enforcing it for just over a year.
Thank you so much, Peri, for detailed comments. I'll come back to you on the regulatory dialogue. But before that, Shilpi, I come to you. What are your thoughts in the background of what Peri has already mentioned? And most importantly, what makes me curious is that, time is passing, right? What is really keeping the government, the Indian government, and in fact, such legislation is being proposed in Brazil, if I'm correct, right? There are other countries which are basically have made a proposal like the DMA, but for some reason, there are second thoughts whether they should actually enact that law or not, right? So, what are your thoughts in terms of this lack in time? Over to you, Shilpi.
Thank you so much for having me here, Sumit. So it was really interesting and such a fantastic sort of summary with so much of sort of detail given by Pierre. I don't know how you did it, but that's really, really nice, and also good for us to hear about what's happening. So in India, of course, as Sumit said, the draft digital competition bill was a, a a form of it was put out for stakeholder feedback, and I believe a lot of feedback was given to the ministry. And the ministry then also, I think, subsequently, there have been representations made and they've had meetings. So I think they are in the process of looking at that. I'm unfortunately not in a position to tell you what is happening with the bill, because that's not my area of expertise. But I mean, anyone in India knows that has been a very divisive bill. And there's been a lot of pushback to it. So obviously there is more careful consideration being given to the bill, given the kind of negative feedback that it has received from a wide spectrum of stakeholders in India, including lawyers, obviously big tech companies, a number of think tanks, etc. But in the meantime, the CCI has been active in its enforcement in digital markets. So as Sumit mentioned, we do have a number of cases that have come up in the last year, and also the CCI is investigating a number of other cases. So one thing interesting that Sumit didn't mention was that we have in the last few months a settlement that are a newly so we have a new settlement and commitment framework under the Indian Corporation Act, and the first entity to have settled under that framework is unsurprisingly Google, with respect to the Android TV operating system market, and it has agreed to basically enter into a new agreement, which it calls a New India Agreement, where it will unbundle the Android operating system from Play Store and YouTube and other Google apps. So under the new agreement, you can license the operating system, and you can pay a fee, and you don't have to. You can pay a fee for getting Play Store, and you don't have to take the whole bundle. But the bundle still remains. So you can still opt for the bundle, and that has been a matter of dissent within the CCI. So there was a dissenting note to the settlement where the dissenting member said that sort of allowing the bundle to still remain doesn't really solve the competition problem. So we do, so that's an interesting sort of new development. Also, the anti-fragmentation part of that conduct, where sort of the concern was that that Google is imposing sort of, or is restricting the forking and fragmentation of Android. The settlement decision, in my view, doesn't really adequately take care of that aspect of the conduct as well, because again, sort of, if you are if you want to license the Google Play Store, you have to have an Android compatible device. So it doesn't allow Play Store to be licensed for non-compatible Android, so for fragmented Android devices. So in my mind, there are some challenges that this first settlement decision has presented, but it has been a speedy resolution. So that's an interesting development in India. And in addition to that, as Sumit mentioned, so we are drawing from sort of the European competition jurisprudence quite a bit in some of the things that we're doing. So with respect to the WhatsApp abusive dominance case, where WhatsApp has been, as Sumit mentioned, very similar to kind of what's happening in Europe, but a bit different, because in India, and I think this didn't happen in Europe because of the regulatory structure of Europe, that we received a privacy policy update in India from WhatsApp saying that if you want to continue to use WhatsApp services, you have to agree to sharing your data with the Meta group of companies. And the take it or leave it nature of that WhatsApp policy update, where the choice is either you agree to this or you stop using WhatsApp, given WhatsApp's position in this market, CCI found it to be an abuse of dominance. And they also found that this would strengthen WhatsApp's position, or generally Meta's position in the market for online display advertising. So here we have taken, I think, a bit from EU jurisprudence, but also developed our own jurisprudence around sort of thinking about WhatsApp's conduct, both as an exclusionary abuse of dominance and as an exploitative abuse of dominance. And then we are also kind of facing some sort of challenges with compliance with the CCI, enforcement of the CCI's orders. So this is something where I think Claire has addressed quite extensively, but we're also having our challenges. So for instance, in the CCI found Google to have abused its dominance in Play Store, which of course sort of we outlined that quite well. But so a similar kind of thing, anti-steering provisions, high commission rates, etc. So the CCI said that the anti-steering provisions are an abuse of dominance, but they did not comment on the high commission rates because they said that we're not really in a position to say whether this kind of rate is excessive. So at that time, they stayed away from that. And I'll come to that in a bit. And then they also said that this is interesting to me, that the fact that YouTube doesn't have to use Google's billing system, but its competitors have to do it, and they have to pay that high commission rate is an abuse of dominance because it discriminates between YouTube and competitors of YouTube. So, so they said this is an unfair imposition. So those were the main conducts, is also leveraging, etc. But on appeal, and this happened recently. So on appeal, the appellate authority in India has upheld the anti-steering part of the CCI's order, saying that this is an abuse of dominance. But this the appellate authority did not find that there was any discrimination with respect to YouTube not being subjected to Google Play's billing system, but its competitors having to do it. So that part of the order was removed. Now, in the meantime, what has happened in this case is that Google has kind of tried to comply with this anti-steering provision and the imposition of Google Play billing system by sort of introducing the user choice billing system, which I'm sure all of you are familiar with, which doesn't really solve the problem in that sense. And so now the CCI is undertaking another investigation because a number of these app developers have come to the CCI and said that this is problematic. And now they're actually investigating whether the commission rate is excessive. So whether that excessive commission rate is an abuse of dominance, which they had stayed away from earlier, but they're now investigating. So now they're kind of, I think, going into that territory, which I think is the main area of concern from a competition law perspective for app developers. It is the high commission rate. That is at the heart of the concern, and now the CCI will be looking into that. So, and that's basically because the compliance is so problematic. So I think in that sense, at least through the settlement framework in India, we are focusing more on how to remedy the competition law issues in the market, which so far has not really, the CCI has not been very good with kind of ensuring that its orders get enforced, and the remedy part of its orders are often significantly overturned at the appellate stage. So even in the WhatsApp order that I previously talked about, at the appellate stage, the CCI had ordered that WhatsApp be forced not to share its data with the Meta group of companies for a certain period of time. And that has been stayed at the appellate level because the appellate body felt that this will unduly impact WhatsApp's business model. So with respect to sort of the CCI is active, like I said, on a number of different fronts. We have a number of different interesting sort of cases, investigations going on. But how successful has it been to really remedy markets? That's a big question mark, because both in terms of conduct remedies, etc., as well as in terms of penalties. It hasn't really been able to successfully enforce them and successfully collect them and successfully implement them, because it gets stuck at the appellate stage. So I think that is a matter of concern. And I think that is an area where sort of having an ex-ante regulatory framework will be really helpful in the Indian context. But we have to see sort of how that really gets implemented. So that's a brief kind of view from what's happening in India.
Thank you so much, Shilpi. I'll come back on the lack of enforcement of the CCA orders, because that's an interesting area. Kelton, now I come to you. I followed some bit on the Canadian side. I think the Canadian Competition Bureau is looking into advertisement technology. They have also recently opened an investigation in algorithmic price collusion, right? So, how is basically competition concerns in digital markets panning out in Canada? And also, what is the legislative framework in terms of, whether Canada is also looking onto something like, an ex ante rules in the digital markets, or the current exposed, the conventional competition law is something which is being found sufficient there. Over to you.
Oh, first off, thank you for having me, and appreciate learning a lot about both what's going on in Europe and India as well in this file. So for a bit of background, to date, Canada's approach really has been anchored in traditional competition law, so that ex post investigatory case by case approach. At least when it comes to competition, there's been a number of legislative efforts related to things like funding for journalism, as well as ensuring Canadian cultural content. But on the regulatory side, the action really has been in strengthening Canada's Competition Act, which is our main federal piece of legislation. And so in 2022, 2023, and 2024, the last two of those being kind of the most material, there was a real strengthening of our laws, particularly in the area of mergers, particularly in the area of abuse of dominance, as well as, and something I'll refer to later, and it's exciting to hear about in the European context, is opening up of private access to Canada's competition law, something that's been quite centralized with our enforcer, the Competition Bureau. So we've made a number of strides, and the Competition Bureau is really stepping up its level of activity, both for kind of these digital markets efforts, as well as a number of important domestic markets, everything from real estate to grocery to gas stations. That last one, an investigation focusing on whether or not industry pricing software is dampening competitive pressure. And so I'm excited about that, and we're happy to see those changes. But a couple of caveats, and Pierre raised one of them, is the classic kind of time to action between starting a competition law investigation and actually seeing some sort of remedy to the conduct. So the Competition Bureau is going after Google's ad tech monopoly in a case that is, structurally pretty similar to the US DOJ's case. They started investigating Google in, I believe, late 2020, early 2021, and that case is set to go to trial in early 2027. So, I mean, that's potentially an exaggerated issue, an exaggerated example. And I think the nature of the investigation changed, but it really is unfortunate when you don't have this merger deadline, that an abuse of dominance case, there's very little incentive to address them quickly. And I think for a variety of reasons, the Competition Bureau has not pursued interim injunctions for abuse of dominance conduct. There's a high bar, and I think there's also some conservatism there, small c that is. And so we really are wrangling with that, and it is tough. We've got a very powerful potential set of tools to address issues in digital markets, but the timeline on these is, quite extended. And today, the big thing that I'm worried about is, you know, just a week or two ago, Canada backed off its digital services tax in response to pressure from the Trump administration. It strikes me as entirely possible that, like the DMA has attracted the attention of the U.S. White House, Canadian efforts to kind of rein in some of the excesses of big tech could become a piece of this trade negotiation. So that is, if something's keeping me up at night, it would be that. To talk more about sort of ex ante approaches, that's been fairly absent from Canada's conversation these days, and I think that's a problem. But I think there is an opportunity, especially in this kind of current environment that we're in, that Canada can look to other allies around the world, whether that's Europe or India, and find common ground on issues that allows us to collaborate and set some sort of standard for conduct in these areas while still preserving the ability of individual nations or blocks to set their own approaches. And I think the European community, thinking of the Commission in respect to the Germany's competition authority, different approaches that work in a collaborative fashion, really, I think, is the way forward if we're going to address what are fundamentally global problems. So, to sum up, I don't want to run too long, is Canada really has doubled down on a traditional competition law approach, which is good. It was very overdue. We had quite a lackluster set of laws, whatever market you're talking about. But that approach has a number of risks that I think have only intensified in the past 6 months to a year. And I think we really need to be thinking about today what kind of collaboration, cooperation with other countries that are facing the same issues that we need to be thinking about if we actually want to be able to regulate and have some say over the operations of these companies, not just in competition law, but in privacy, online safety, taxation. I think all these things are on the table in this sort of new environment.
Thank you so much, Keldon, and for specifically bringing out this, geopolitical element. Pere, I come to you. The White House has officially shot a letter to the European Commissioner, right? That the Digital Markets Act unfairly, quote unquote, targets certain US companies, right? And it is some sort of a quote unquote tax, right? As Keldon mentioned, this is happening even in Canada, which is basically Digital Services Act. We in India are also facing this, but mostly on the line of trade, not on the lines of competition law. So, would you like to share some thought how this sort of pans out when you are having regulatory dialogue? Because there is some documentary, there is some evidence which is being documented now that Google specifically is using these regulatory dialogues not to rather basically engage productively, but rather attack the legitimacy of the law itself, right? So any comments on that? And specifically when we are talking, when we're sitting in India, right, this regulatory dialogue becomes extremely important. However, what is also often repeated, and we have also mentioned at one point of time, that the regulatory capacity also becomes a concern. There is some commentary available that for entities where the size of competition authority is a bit small, right, the question of regulatory dialogue might be a bit counterproductive because there is a possibility of regulatory capture, right? So, Pierre, if you would like to share some thoughts on that.
Okay, I'll first respond to your first question on the interference and the US and this question of tariffs, right? Which is, I think is normal. But we stand strong, right? I think the message from both the president of the European Commission and from both the European vice presidents, Rivera and Virkkunen, both of them overseeing the implementation of the DMA, is that compliance with European law in general, the DMA in particular, but any European law in general by US companies cannot become a bargaining chip in trade negotiations, right? The DMA has been voted and approved by the European Parliament that represents hundreds of millions of European citizens. And I think it is, you know, very difficult to believe that we will backtrack on this mandate. The DMA in itself applies equally to all large digital actors operating in the EU, irrespective of their place of incorporation. You know, American companies have been designated gatekeepers, Chinese companies have been designated gatekeepers, European companies have been designated gatekeepers. And that is the mission of the DMA, right? Is just to ensure safe, fair, and a level playing field in the EU, irrespective of, you know, where the companies are based. And, you know, again, the rules have been crafted to align with international trade rules on non-discrimination. This is no different than our antitrust rules. We have sanctioned non-European companies that are active in the EU that engage in cartel behavior or abusive behavior. So there's nothing really fundamentally different with the DMA. It applies exclusively within the European Union, and it has no extraterritorial jurisdiction, right? Neither in the US, neither someone else. Gatekeepers only have to comply with the DMA here. They need to change the rules if need be here. But if they don't want to change the rules in the US, in Canada, or India, then that's our problem. That there's nothing we can do, and there's no influence that we can have outside those jurisdictions. So at least that's, you know, my sort of 2 cents on this, you know, influence from American politicians at the moment. And you had a second question, I think, but if you could just repeat it.
On the question of regulatory dialogue, in terms of there is some commentary, academic commentary, that for countries which have small regulatory capacity, for instance India, right? We only got our competition authority in 2009 functional, which is 16 years old. Now, of course, 16 years is a good time, but of course, if you compare it with other countries, it's a bit nascent regulator, right? So there is criticism that too much of regulatory dialogue might also result in regulatory capture, right? Because these entities which ought to be regulated through the legislation at the very first place, they might sort of use this dialogue to ultimately, which is very often in sectoral regulators, by the way, right? One sort of advantage with the competition authority, sector agnostic, right? So how do you basically address that?
No, I think it's a fair point. Again, we at the Commission, but I think any sensible person would tell that there's no point to regulate things that don't need to regulate if they're working well, or if we already have pre-existing tools. When it comes to digital, I think there is a global consensus. It's not just Europe that, has pointed to the fact that these large digital platforms have become very big and that these sectors, markets, don't function properly. We had the studies in Europe, we had studies in the UK, we had studies in the US. Japan has issued regulation, South Korea, Australia, South Africa is looking into it. We mentioned Brazil. So, it's not an isolated issue. So it is a global issue because these services are roughly the same across the world, right? There's nothing specific to the EU. Google search is Google search. There might be some, local variations, but as such, the platform and the service is the same. So I think when you have identified global issues, I think it's also important to tackle these issues in a global manner. right? If we tackle these issues only in Europe, good for us, but it's not going to take this issue away, right? So it's not because India has only recently started looking at this, or the legislation has been recently there for not long, that means you don't need to do anything. If the issues are there and you cannot tackle them through your tools, pre-existing tools, which is the conclusion we came to in Europe, then you need to do something. You mentioned this sort of capture in the regulatory dialogue. And this is why we have always tried to be as transparent as possible. We don't want this behind closed doors negotiations where we discuss with the gatekeepers, we sort of agree to something that looks okay, and then we come to the market saying, this is what we have agreed, this is what's going to roll out, and the market says, this is completely off the mark. So being transparent, discussing to stakeholders, asking these gatekeepers to publish on their website what they want to do so they can collect feedback. We've also asked gatekeepers to organize workshops, meetings, one-to-ones with their developers so they can discuss this. This really allows a sort of virtuous circle where everyone gets their input, and basically you have a counterbalance to what gatekeepers put on the table. And I think this is really a great safeguard when it comes to the capture that could exist when it comes to discussing with these gatekeepers.
Thank you so much, Pierre. Shilpi, anything I would like to share, whether there is some sort of, this international pressure is acting in the case of India as well. Because, we have seen multiple times that the current US government is going heavy when it comes to even on trade, imposing tariffs on countries which are not cooperating. This being the first part. The second part, of course, you mentioned that there is some lag in enforcement of the CCI order, right? So what is the possible solution for this? Because even if you would see commitment and settlement regulations, the burden of appointing a monetary agency, right? Even though CCI has kept the last word for itself, it has sort of said that the monetary obligation to having this the agency which will ultimately monitor and enforce the settlement and commitment order, right? The monetary cost of the same have to be borne by the company which against which the order is being passed. So these, if you can answer these two aspects.
Thank you for that, Sumit. So actually, what I heard on the grapevine, which I don't have any official sort of news on, is that, like Keldon said, our sort of draft digital competition bill is also partly maybe one of the reasons why there's no like sort of further news on what is happening with it, is maybe because of the trade dialogues going on with the US, and the US is putting pressure on India not to have ex-ante regulation in digital markets. So that is just what I've heard very informally. And it's like, given what both Pierre and Keldon have said, I don't know, it seems to, in India, it seems to make sense, but also like there has been so much of internal pushback on the ex-ante framework in India that I think there are a lot of different factors that are playing, and there's a general sentiment with respect to this bill in India that it's going to chill innovation, it's going to hamper our vibrant startup ecosystem, and there's a general sort of feeling that India is different from Europe and we shouldn't just copy Europe, and we have a very vibrant startup ecosystem, which, I mean, I have my own thoughts on that, but won't go into it. But so there is a general negative view of the ex-ante framework, also because of the thresholds for designation of the gatekeeper in India that we call the systemically significant digital enterprise is very low. So it will catch a lot more enterprises than sort of the designations that we have under the DMA right now. But I think that it's a very complex, but I think there are a lot of different interest groups at play that are sort of giving their views on. It's not just what's happening at the US, though that might be, but I'm not really in a position to say. It's just what I've heard informally. But I think maybe restructuring, because earlier there were talks about sort of restructuring the digital competition bill. So, and addressing the concerns that have been raised, which I mean, I think is what they should do. Because as we've discussed and what everyone has said is you, the traditional competition enforcement, even in India, as Keldon said, even in India, it's very slow. Not just that CCIs, I mean, the orders are not reaching finality either, right? So it's not just that we're not able to enforce, but we've not had, we've had very, very few CCI orders in general reaching the final appellate authority, which is the Supreme Court of India. So until that happens, sort of everything is very uncertain. So for instance, I think Sumit, you wrote about this recent Indian Supreme Court abuse of dominance case where they have now imposed an additional requirement, which is adding the effects-based approach to abuse of dominance cases, which will really change how the CCI views abuse of dominance cases, because it hasn't been systematically doing an effects-based approach for all abuse of dominance cases. So one judgment from the Supreme Court can really change the competition jurisprudence, and we haven't had too many of those. So I'm wondering sort of when all these sort of digital market cases go up to the Supreme Court, what's really going to happen? And given sort of the broad trend I'm seeing, it might be that more is asked from the CCI than what the CCI is able to do right now in terms of meeting the standards for abuse of dominance, etc., under the traditional competition law enforcement route, which then will be very hard for the CCI to kind of enforce in digital markets, just given the capacity that they have. I think they referred to capacity, and we don't have that kind of capacity in India to do that kind of very technical, collecting that kind of evidence, etc., etc. So those are real matters of concern. And to me, I am concerned about what the Supreme Court is going to say, just given what's happened in this recent ruling, in terms of what it's going to say about the Google orders, the WhatsApp order, etc. And just coming to the second point, which is kind of interconnected, I feel, on what can we do with respect to the enforcement. So I think, yeah, that's one of the reasons why we need to have the digital competition bill, because the CCI has the power to issue interim orders. It did that in the MeitY trip case. But it hasn't really used it very effectively beyond that. And unless the settlement and commitment regime, as you're saying, has its own problems, but also just I'm concerned about whether it's really going to solve the key parts of the competition problem that these cases bring out. So that's another issue that will, like, in the either through the settlement and commitment framework or through the stages of appeal that these decisions go through, we're going to lose out on the essence of the competition or issue and the remedy for that issue. So I think that is something that sort of we can really see happening in a more robust way from what Pierre said in Europe. And we need to focus more on the remedy than sort of these nitty-gritties where there is sort of well-established evidence of conduct, etc. But we're still busy in India establishing the basic jurisprudence, and we're not really able to get into sort of how do we remedy this kind of very complex conduct and the market shifting by the time you think of remedies, etc. So those are just some thoughts.
Thank you, Shilpi. I think we are 7 minutes short, but there are a couple of points. In the Scott Glass case, what was also different was that there was a standing minority order against the CCI majority order, right? And that was also a case which was more than 10 years old, right? I will draw a parallel between what happened in the Google Android case, right? That matter went up to the Supreme Court, right? But on the very face of it, the court sort of, made it very clear that, we are not going to interfere into the same. And the CCI order is correct. And I mean, unlike in the NCLAT order, which you mentioned in the WhatsApp case, or there was another case which you mentioned, where the appellate tribunal has sort of cut some part of the orders. In the Google Android case, this does not really happen. The second part is also even the question on overturning the CSAT decision. There is a clear departure in the last 6 or 7 years. So the research which we do tells us that in the first 7 or 8 years, which is between 2009 to 2017 to 18, the reversal rate at the appellate tribunal itself was as high as 25%. Right, but if you would see recent trend in the appellate tribunal at least, because in Supreme Court, by the time the decision comes, the matter already is lost, right? Because you don't know how much time will they take. But if you specifically talk about appellate tribunal, there is a clear trend at the NCLAT in the last 6 or 7 years to more or less sort of have a more selective approach when it comes to sort of reversing the order. So that's all. But I mostly agree with what you have said. So in the interest of time, we have 5 minutes. Keldon, any sort of concluding thoughts on this issue of largely competition digital markets, how ex ante regulations should be sort of adopted, right? If not sort of taken as it is, not only in Canada but also specifically in developing countries like India, Brazil, to an extent Japan, and so on and so forth.
Yeah, I mean, I'll be quick, or I'll be brief rather. The thing that I want to highlight, and it's something Pierre brought up, and I think it's, again, something that we should really take away, and that jurisdictions like Canada and others around the world should really appreciate, is that transparency element of the DMA. I mean, in Canada, and I think this is the case elsewhere as well, the competition authority will announce an investigation, or they'll announce litigation, and then it will basically go quiet for the intervening period. Certainly in the case of the investigations, certainly in the case of before litigation, and in particular in the remedy. If I think about mergers, remedy negotiations, it really is a black box. And so when the public has no way in to see what's actually going on, and what's coming out at the end of that process is unsatisfying or questionable, I think it really erodes the foundation for trust. And so whether ex post or ex ante, I think jurisdictions, Canada being certainly one of them, have a lot to learn. And I think Europe sets a good example here, which is to say, open up these processes to public input, to public discussion, and to public scrutiny. And then I think all parties involved can feel like they have a bit more of a piece of the process, and understand why we got where we are. So if I want to end on one thing, it really is the value of that transparency, and how much work we have to do, certainly in Canada.
Thank you, Keldon. Pierre, concluding thoughts.
Not really. I think it's what this conversation has highlighted is that, we all seem to struggle with the same issues and how to tackle them. And I can only wish for, additional convergence and cooperation between authorities to tackle these issues that all of us have identified.
Thanks, Piri. Shilpi, any concluding thoughts on the matter?
I just wanted to clarify one thing you said on the Play Store order, which is the NCLAT did significantly reduce the remedies at the appellate level, on the Android order, that they did reduce the remedies in the Android order as well from what the CCI kind of ordered. So there was already that happening. That was just a quick clarification, but I agree with everything all of you said, and I think we do have to learn and take the opportunities to learn. And not just think that we're different, but think about sort of, what has been happening in other jurisdictions, and how sort of there are similarities, because there is a lot of the conduct is very similar across these jurisdictions. A lot of the challenges are very similar, and we need to, at least in India, we really need to kind of take that opportunity to benefit from what other jurisdictions are doing.
Thank you, Shilpi. I would like to thank all the panelists to spend time on this very relevant issue, and most importantly, agreeing to sort of speak on this issue. I think what I learn from the conversation today is that a lot will happen. Is yet to happen. There is certainly no word, why is this sort of this legislation which is being proposed. I think Shilpi correctly mentioned that there is a lot of negative feedback, not only the geopolitical pressure, but also internally there is some sort of pushback in India. Some food for thought for for our viewers is that whether when you talk about this ex ante approach, right? There is some discourse also happening whether these developing countries like India, Brazil, Japan, and so on and so forth, Korea, for instance, right? Whether there is some sort of specific approach required apart from this ex ante rule and also sort of different from the conventional approach to sort of intervene on a pro efficiency basis when it comes to digital markets. So I think this being my own learning, I think a lot of questions are open and there are no easy answers. As Perry correctly mentioned, that there are a lot of struggles yet to be sort of coped up with. So I think this being the overall discussion. Thank you so much, Perry. Thank you so much, Shilpi, and thank you so much, Keldon, for agreeing to be a part of this panel and speak to our viewers. This conversation is already being live streamed on the YouTube. We would be preparing a memorandum as part of this discussion and we would be sending it to the Indian government. Thank you so much again for being here.
Thank you.